everyone, and welcome to today's program, Mastering Brackets in Mediation. I'm Ala Policastro, Director of Education and Professional Development at Beverly Hills Bar Association, and today I'm delighted to introduce our speaker, Diana Maier. Diana is an award-winning employment mediator with signature resolution. As an attorney, she has nearly 30 years of experience handling complex workplace disputes from both plaintiff and defense sides. Diana has also served as in-house counsel in employment and privacy law, conducted workplace investigations, and founded her own firm, Maier Law Group. Rounding out Diana's experience is the public office she holds in Marin County as a member of the board of directors of the Marin Municipal Water Board. Diana's work as a mediator at Signature Resolution focuses on employment lawsuits in both single and multi-plaintiff cases. In addition to her work as a private mediator, Diana has served as an impaneled mediator for various courts across California. Her professional accolades and memberships are just too many to list here today, but do include Northern California super lawyer multiple years in a row for her work as a mediator and employment attorney. We're so excited to hear what she has to share with us today, so I'm going to turn it over to her now.
Great. Good morning, everybody. Great to be here. I'm going to now share my screen with you so you can see the presentation. Okay. Hopefully that you can see that nice and well. Yeah.
Actually, Diana, could you share, could you restart the share and
Sure.
share the application? It looks like we shared the desktop.
Oh, I'm sorry. There we go. How's that?
Perfect.
Okay,
Yes.
thank you. All right. So good morning, everyone. This is Mastering Brackets, and I thought I would start by just giving you an overview of what we're going to talk about today. I went through this presentation many, many times and had some signature mediators watch it with me and was a little confounded on now that I've used brackets a lot, they have become pretty second nature, but trying to explain them in a way and getting into the math piece of them that felt really accessible and smooth and easy was a little bit of a challenge. So ultimately, what I thought would be best was to use a hypothetical and that would give some realness to the presentation. So I'm going to start and take a few minutes to go through a hypothetical. So bear with me. We're going to come back to that hypo again and again. So I want to introduce how this could be used in a real case. Then we're going to talk a little bit about what brackets are and when to use brackets. I want to talk for just a few minutes about when using brackets might be less than ideal. And then we're going to talk about problems with brackets. And finally, I will get into some closing thoughts. I don't need to go through this because I was introduced, but if you should want to reach out to me after the presentation, if you have any questions, you can dmair@signatureresolution.com is my email, and that is actually my cell phone right there. You can always feel free to reach out to me. All right, so starting with our hypothetical. So company good intentions, which I call GI, has been in the Hollywood market for many years, employing various tradespeople who build sets. And given all the mishigas going on in Hollywood, there has been less and less need, and they have started to scale down dramatically and laid off a huge portion of their employees. They have been pretty good about most of their legal obligations, but really haven't gotten top-notch advice on wage and hour policies. So when they lay off a tradeswoman, Jane Jackson, she goes to a plaintiff's employment attorney, Archie Archer. And Archie, as any good plaintiff's attorney would, gets her personnel file and her time cards. And he sees right away that GI has not been paying a premium wage to its employees when they miss lunches or they're interrupted or taken late. And that also the company looks like they've been engaging in rounding. And he explains to Jane that these are two cardinal sins in wage and hour law, and there is probably significant liability here for the company. PAGA, class action, and so forth. So he writes a demand letter, and then Company Good Intentions or GI responds. They hire a really good attorney, Barbara Brilliant, and Barbara takes a look at the facts and tells them that they need to be prepared to pay big time, that this is probably, given the number of employees and the pay periods and the errors, this is going to be an issue for them. So GI shows Barbara their financials and says, we understand and we understand we've made some mistakes, but we've laid off 80% of our staff and we just have no money. And anything over 750,000 is probably going to bankrupt us. So Barbara says, look, let's go to mediation. We can turn over financials to the other side. This plaintiff's attorney is a compassionate person. He's not going to want to put the company out of business if he can avoid it. He realizes that's not going to do anyone any good, but he is going to expect that every last dollar you can come up with, you're going to pay out on this suit where you have pretty clear liability. So Archie and Barbara put their heads together and decide they're going to hire a mediator, Calm Carl, who really likes to use brackets, especially in matters like this, where you've got big numbers on the table and some real problems with how people are going to get to a settlement that both sides can live with. And Archie basically starts out the mediation telling Carl that, look, I understand the financial position. I've looked at the records, but I also think that this case merits a sizable settlement. So I expect expect the defense to put money on the table. He begins with a $10 million demand. And Barbara Brilliant, who is very aware of kind of where the company can go at the end of the day, starts with a lower response than she might normally, and says that they will counter that demand with an offer of 20,000. Okay, so that's where we are at the moment. And I just want to reiterate that the stars of our drama are Archie, who is a plaintiff attorney, Jane Jackson, who's the named plaintiff. She doesn't come up that much, but I will say Jane periodically. Barbara Brilliant is the defense counsel. Her client is GI, the defendant company. And then, of course, Carl is the mediator. So what are brackets? Well, first, I want to talk a little bit about what brackets are not. In a traditional settlement negotiation, and many of you, of course, probably have done this many times, but some of you might be newer, so I want to go through this. Parties are typically exchanging demands and offers, and they're moving from opposite poles to some kind of a number in between. Might be much closer to where the plaintiff started, might be much closer to where the defense started, but that is the idea that eventually they'll reach settlement. Each offer that's put on the table, each demand is a signal. If you pay this demand, the case will settle right now. And conversely, the defense is saying, if you're willing to accept this offer, this case will settle right now. So the numbers have a commitment to them. And if we use that in our scenario here, which is generally how these things go, we end up with a tit for tat scenario. So I will tell you that in my mediations, I always want the plaintiff to arrive first. So I have them come sometimes a whole hour before the defense. I like to really get to know the plaintiffs. And I want to, kind of lay the groundwork and not waste defense counsel's time. And then I get into numbers with them. So and then defense comes, and I spend quite a bit of time in that initial session getting to know those clients and, of course, the attorney if I don't know the attorney, and talking a little bit about why the plaintiff is where they are and what their number is. And then we get into numbers. So those initial meetings are for me, definitely the kind of longest part of the mediation. And it might be a couple hours into the day, therefore 2-3 hours into the day and we've only exchanged a couple of offers back and forth. So, pretty quickly after that, like many mediators, I move pretty quickly, and it might only take an hour to exchange a couple of offers, but say we start the mediation at 9, it might already be noon, and we might have traded. So Archie then say goes to 9.8 million. Barbara might move up to 40,000, saying, okay, well, he's moved a little bit, but not nearly as much as we need him to move, so I'm not going to make a big move. Then Archie might say, well, that's not where I want them to go, so I'm going to just move down to 9.7. And then Barbara might slow down even more and say, I'm not going to keep doubling my number. I'm going to go to 50,000. So does this sound familiar to some of you? I imagine it probably does. And the parties are going to remain basically over $9 million apart. Maybe that's a tad of an exaggeration in a real life mediation that I go into, because usually I work on the parties, even with their initial number. But there is a large discrepancy here. And so we might be a couple hours into the day and not really know if this case is going to settle and what ballpark it's going to settle in. And I wanted to just graph this out for you. So some people are visual learners, and I just thought it would be helpful to have it up here on the screen. Please don't, the numbers, the exact numbers themselves are not very important, but what I'm trying to show you here is how big this range is between $0 and $10 million, especially knowing that the plaintiff is pretty hamstrung and how much, defense is hamstrung and how much they can offer. And we've got an initial gap, maybe 2 hours into the mediation, of still $9.98 million. We have a couple of movements, but we're still not that far apart. And so we really, again, we don't know whether the parties will settle. And I just wanted you to see that graph, to see that in relative terms, we've really moved very little. This is where brackets come in. So bracketed demands and offers are pretty different from traditional demands and offers. And I would like to suggest that their biggest value is the fact that they're contingent. So neither side has to take the risk that if I make a big move, it's not going to be rewarded. And that is something that I often spend a lot of time talking to the parties about. And we'll talk about that a little bit today, but this idea of kind of throwing out an X card that another is rewarded with another X card, or a tit for tat, as opposed for a more meaningful move, which is often called a Y card move. And so the parties can stay in this fear-based negotiation, throwing X cards at each other for a long time. Bracketed demands and offers allows for the party to come up with a conditional move that necessarily has to be rewarded by the other side. So they say, I will move to X, fill in any number here, but only if you move to Y, fill in any number. So in this case, Carl says to Archie, let's try this because we're really not making a lot of progress. And I actually think you two are not as far apart as you think you are. And again, just to graph it out for you, in a traditional negotiation, right, we move pretty slowly here. And a bracketed negotiation, Archie says in one move, for example, if we move down to 8 million, so that's a pretty significant jump. That's almost $2 million, a reduction. Will GI come up to 500? We'll do that if GI promises to come up to 500,000. So they're saying, look, we know you can't necessarily pay millions and millions, but you need to start putting some real money on the table. And you can see that just with this bracket, the gap has already narrowed exponentially compared to prior moves. Now, that's not going to be a bracket that is necessarily going to be accepted, and it's not going to be the last bracket that is exchanged. But you can see that if this goes on, we can make progress so that we can get a deal done by the end of the day. And again, I thought I would just graph this out for you. So initially with the gaps, the initial gap was $9.98 million with the first move. And now we had a couple more moves. We reduced that a little bit. But now in one move, the gap has gone all the way down to 7.5 million. So still a big gap, but again, we're just getting started. So while the defense is unlikely to accept that bracket because 500 we know is getting kind of close to their bottom line, they're going to generally return a bracket of their own, and their intention is also going to be to lower the gap. Brackets get their name because they act as a boundary to numbers being placed on the table. So mathematically, they are expressed as a range, and that range would be X, which is one number, to Y. And in this case, since we were talking about a bracket, the demand that the plaintiff threw out, I'm doing the bracket 8 million plaintiff number going down to 500K, which is defense's number. That's the bracket the defense, the plaintiff, excuse me, the plaintiff proposed, indicating that the case could settle somewhere between 8 million and $500,000. So I want to ask you now to take a minute to think about why Archie agreed to go along with Calm Carl and suggest this bracket. Do you think it was A, boredom? By the way, you're going to put this in the Q&A, and you could put A, B, and C. You could put the words, or ideally, if you have something interesting that you want to share, go ahead and put some comments in there as well. I'm going to give you a moment or two to fill this out. But here's the question. So Archie did this because he was bored, because he hoped the defense would commit to putting some real money on the table, that none of this 40,000, 50,000, but let's talk about a number that where we're really starting to move. Because he wanted to demonstrate that the plaintiff intended to move significantly off its demand. He wanted to reassure them, hey, I'm here in good faith. I'm going to move. Don't worry, but you've got to move too. All three, or E, none of these. So again, if you say none, maybe explain your answer there. And otherwise, I'm going to give you a moment to put your answers in the chat. Excuse me, in the Q&A. Okay. I'm just uh interesting how there is a big variety of responses. I think that the answer is uh could be all of those things, right? And this is why brackets are both a valuable tool and can be a frustrating a tool for attorneys, because brackets really shake things up, especially when the parties are having decision fatigue or feeling discouraged. They can be a really valuable way. So, Archie might have just said, we could be doing this all day and it's going to get really old. Or he might have done, I think, the other two. And it could be any of those. We don't really know. I think generally it's all three of those. It's like, let's try something different. And also, I want to signal I'm here in good faith. I'm a reasonable attorney, and I know that I've got to give them some reassurance that I'm going to move too if I want them to move, and I want them to move. So brackets value is in the fact that they are a low risk way of the parties exploring possibilities for settlement where none before existed. I think that brackets are best used, and they can be used in a lot of different places, when the process is stuck or moving slowly to work well because of all the reasons we just talked about. Carl might have suggested the bracket there, the mediator, because he saw that the parties were moving pretty slow, and said, look, I want to get this done, and I don't want everybody to just sit around here all day. Let's see where we're really at. Barbara might be concerned if it weren't a bracket about going too quickly given GI's financial position. So the brackets let her condition a big move on the plaintiff also moving. Here is a bit of a summary in my mind of when I think brackets are most helpful. So using brackets when a single number negotiations are hitting an impasse is a good time. When there's large gaps that aren't being bridged well, those of you who've been to a mediation or might have mediated before, you know that there can be these two opposite narratives that go on, both having value, right? Of Jane and Archie saying, we can't do anything because the defendants won't put serious money on the table. And I can understand how the 20, 40, 50 numbers might be frustrating. And I can also understand how Barbara and GI might say, this number is a non-starter. We can't offer more because we can't. What are they thinking? $10 million. So the narratives can get really stuck, and you need somebody to break that cycle. You need somebody to say, all right, I'm going to stop putting punitive or performative numbers on the table. I'm going to make a real move here. And finally, I think that brackets are great when there's simply decision fatigue and smaller successive moves. So sometimes you're doing great, and then you start to get towards the end of the day, and the parties are just really fatiguing, and it's just time to really bring the thing home. Um, and again, I want to just say very quickly that, another way that you can do this is this idea of throwing a Y card on the table. And X cards versus Y cards is kind of a game theory term. And it basically is this idea that everybody finishes best if each side is making some real movement and taking a little bit of a risk, knowing that the other side will reward it. That's called throwing a Y card, is basically making a move that's not kind of a tit for tat move, but I'm going to make a serious concession here, and I'm going to expect that the other side will reward it. As much as I often spend my time pushing the parties to throw Y cards, it can be really hard to do because they're so afraid the other side won't reward it. So this brackets allows us to get around that. There are only a couple of times I think brackets are less useful than others. Um, and again, with the one caveat of if you've got to know how all the parties are using brackets, and we'll get into this a lot more later in the presentation, but that is the only time when I think brackets can be a little disastrous. So there's a couple of things, a couple of times that I think they're not as helpful. Sometimes right out of the gate is premature. Again, starting with kind of warming people up, starting with some numbers, seeing if you even really need to go to brackets is a good thing. Sometimes I do get into mediations and I just feel like the attorneys know one another. There's some trust there. Some real numbers are exchanged quickly. We finish in a couple hours and we're done. We never had to bracket. But sometimes and sometimes it can be a little bit early right out of the gate. However, I do know mediators that will use a kind of bracket-like approach if they feel that either the plaintiff or defense has just putting a number on the table that's completely unrealistic and is going to derail negotiations. So again, I don't want to put any hard and fast rules, but I would say generally going to brackets right away, especially because they can be confusing, is not always the most helpful scenario. I think they're better towards midway or even towards the end of the day when you really want to get things moving. And then the last thing I would say is obviously don't use if you don't have a good range to move in. So it necessarily implies that there is some range to move. And instead, if you really don't have a lot of range, you might want to pass on to the mediator that look, I'm going to make one more move, and maybe you throw a Y card onto the table and say, look, you need to tell the other side that we're getting very, very close to our bottom line. So this is a move thrown with purpose, or a Y card thrown with purpose. But there's just not enough room to make brackets a really functional tool. So if brackets are so great, why are they dreaded? Why why did it take me so many iterations of this presentation to come up with something that I felt would really be somewhat interesting and also accessible, because they're complicated essentially. And the thing that I think makes them a powerful tool is also the thing that makes them a little bit tough. So let me just give you an example of what I mean. In the offer that the plaintiff made of coming down to 8 million, a defense came up to 500,000. So Archie said, we'll come down to 8 million if GI comes up to 500,000. What number there do you think was the most important? Do you think that was the midpoint of those two numbers, which is 4.25 million, saving you the math? Do you think it was the endpoints, which are 8 million and 500,000? Do you think it's both the endpoints and the midpoints, or none of these? And again, I'm going to have you put this in the Q&A and explain your answer. Oh, someone just said, I know you have no D. Sorry about that. Um, I meant that to be D. Okay. Yeah, so I think that the answer here is, again, it depends a lot on who you're asking. Um, and, the lawyer and the mediator might have a different concept of brackets. Um, but um, both the midpoint and the endpoints can be very important numbers. And there are times when I think the midpoint can be more important. And there's times when I think the endpoints can be more important. And we'll go through some actual examples, but I kind of wanted to warm you up a little bit on the math and start with the conceptual things first. So here are some of the reasons that lawyers really do not like brackets. If you think the midpoint is important, and most people do, and I'm going to argue today that it is a very important number, you've got to keep track of it. I want to just say that for those of you who aren't super math savvy, the best way to calculate the midpoint is simply to add the two numbers together, whatever the bracketed numbers are, and then divide by 2, right? So you're essentially taking an average of the numbers. But you also have to be, sometimes if you move the endpoints incorrectly, or you move them without regard to how the other side is going to perceive them, that can derail things. And again, I'll have examples of that. There are times when it's confusing to know who's going to move next. And then finally, is there this question of, should you propose a public or a private number? And what I mean by that is, do you throw a number on the table that is traded to the other side, that's a bracket that's proposed and is used as a bargaining tool? Or do you use what's called sometimes blind brackets or confidential brackets or a private number? These are all really the same thing, which means you relay in confidence to the mediator what your bracket is. So what complicates things is that different mediators and different lawyers for that matter use brackets differently. And there is not a wrong way, so long as the parties understand the method and the mediator or the party explains how she's using them. So again, if one lawyer really likes brackets, but really feels strongly that there's too much emphasis on the midpoint, then she should be clear about that and say, we're proposing this, but I want to say that we're not making a commitment here to resolve at the midpoint. We're going to cover some of the different ways you can use them so you can see what you think what works for you, and you have some more fluency with brackets, regardless of how people or the mediator you're mediating with likes to use them. There are a couple of unwritten rules with brackets. So a lot of people would say that the signal that brackets is basically sending of signals, right? Because these are not numbers, committed numbers you're putting on the table. So instead, it's a message. And the first message is, so in that example of 8 million to 500,000, Archie's saying, I will move within the proposed endpoints of my offered bracket. So if that bracket were accepted, Archie's next move would be under $8 million, right? Because that's what Archie framed the deal as. And likewise, Barbara's next move would be over 500K. The second is arguably that I can see or I can live with the case settling at the midpoint of my proposed bracket. And there are a lot of people in mediation that really, I think, focus exclusively on the midpoint. And the reason I don't love that is two things. First of all, um, if we're only focusing on the midpoint, then it starts to feel just like regular tit for tat negotiation. I mean, really, how is that much different than just exchanging a single number? So that's one big problem. The second is that not everybody feels that way about the midpoint. So if you're overly focused on the midpoint, that can be a problem. Let's just take a moment to back up here about what is the midpoint. Again, just for those of you who maybe don't use brackets normally, pretty simple here. So 500K to 8 million, the midpoint is 4.25. And how did I get to that number? Again, I just simply added 8 to 5 and then divided by 2, and you got 4.25. So arguably, Archie Archer is saying, I can live with this case settling at $4.25 million. Okay, and that's not going to be their last midpoint, but that's the midpoint that they are saying they can live with right now. I think the reason that midpoints has become such a focus of bracketing is a couple of reasons. First of all, if you go back to this range here, and this is a range where we narrowed things not an insignificant amount, but you're still talking about a humongous range, right? And so it's really hard to know. The defense is not really going to know how to move here. Looking at this, they have no idea really what the plaintiff is saying with this bracket. Are they saying that they'll meet closer to 500,000? Or are they saying they're sticking to 8 million, but they just want the 500,000 for the next move? And so midpoints become a way of making sense of the bracket. They give the other side an idea of what to expect next. And essentially they help frame the negotiation as you're moving into a very different style of negotiating. Of course, as we said, the midpoint is, I think, often overly focused on. The issue is that if you don't pay attention to the midpoint, or even if you say to the mediator or the other party, look, I am not signaling the midpoint here. 4.25 million is way less than we want to accept. The other side may not believe it, right? They're still gonna feel that those numbers were picked intentionally with an idea that we might compromise, maybe not square, like right smack dab in the middle, but somewhere in that range. So it is important to keep your midpoint in mind when you propose a bracket. So again, just to show you what it looks like, here we've got the bracket that was offered, the midpoint, and the party might be saying, we're not signaling 4.25. The other side's going to hear, well, that midpoint means something. So the problem with ignoring it is that when people do that, and again, even when the party has said, look, we're not signaling the midpoint, there can be a bit of mistrust that's created, or they can sometimes feel, a party might feel there's an ethical violation on the other side if they really come nowhere near that midpoint. So the midpoint is not something to be ignored, but still keep tabs on your endpoints. Parties can become so focused on the midpoints that they lose track of the endpoints. And I would say there are cases in which the endpoints are even more significant than the midpoints. And I would say that this becomes especially true as you get closer and closer to resolving. So let me give you a couple of examples of what I mean. So the first move, Archie went to 8, Barbara goes to 5. We said the midpoint's 4.25. The second move, Archie says, all right, I want to come down significantly, so I'm going to go to 7.5, but I want that move rewarded. So I'm going to ask Barbara to go up to 1 million. Well, the problem is that even though the plaintiff has reduced their demand to 7.5, the midpoint remains 4.25. And so if the other party is analyzing the numbers and looking at the numbers, which they should be doing, they're going to see that they're being asked to bid against themselves essentially because the midpoint remains 4.25. So really very little, no concessions made here, arguably, right? Archie is still saying, well, the midpoint's 4.25. I want to meet in the middle. I'm willing to come down, but I'm only going to do that if the other side comes up. And again, this is just to show you what it would look like, right? You have different endpoints and the midpoint is still the same. And so the other side might perceive that as not a great move by the plaintiff. And arguably, that's a valid feeling. On the other hand, you can move the midpoint in the right direction, but the endpoint in the wrong direction. So say as a third move, Archie says, okay, I messed up with that last one and I want to regain momentum. And I'm going to go down to 7 million. And I want Barbara just to come up a little bit. I want her to come up to 1.1 million. So the midpoint is now lower than 4.25, and I'll show you the graph in a moment. But what Barbara might be focused on is like, look, $1 million is way too high for us. And now you're going up even higher. You're moving our number up. So that is a way that you can see if you graph it here, if she is focusing on the endpoints and feels that the number put on the table is not a realistic number for her, even though the plaintiff is still moving down, it might send the wrong message. The other reason that I think endpoints matter is that parties often expect, and this is something I sort of learned the hard way, but when I had a mediation and the parties were exchanging brackets and neither side accepted the other's bracket and they really didn't get that close. And I was in particular having one side that I was having trouble moving. And so the other side basically said, well, if they're not going to move more, we're going to just kind of go back to where we were. And it felt like a little bit of a kind of being stabbed in the back to the defense counsel. In other words, if Carl has dropped down to 7 million in his suggested brackets, even though brackets are contingent, the whole point is I'm going to go to that number. If you go to your number, there is often an expectation that the next move will be within those brackets, at least on his side, right? So it was his bracket and he said, we'll come down to 7 million. So there is often an expectation that Carl is going to come under 7 million, even though obviously there's not necessarily the converse expectation that the plaintiff is going to come over 500 the defense is going to come over 500 because that was a number that the plaintiff proposed, not the defense. But there is this sense that the party that proposes the bracket is going to honor the range that they moved themselves to, even in this contingent scenario. Let me just show you what I mean here. So if the plaintiff moved from 7 million to 7.5 to 7 million, the number on the left here isn't so important. That was the number he assigned to the defense. But this was the plaintiff's bracket. So the defense is going to look at the last move to 7 million, and they're not going to be happy if the move after this comes in at 7.1 or 7.2. They're going to expect that that move is going to come in under 7 million. So again, the endpoints really do matter. And hopefully, again, if you're in the brackets realm, you've got plenty of room to move. So this shouldn't be that hard to do to come in at this number that's under the number that you propose, but it is something to be aware of. The other reason I think endpoints matter is because they can say something about where the parties see the opposing side landing at the end of the day. So using our above example again, going to the first bracket we talked about, if Archie proposes 8 million to 500,000, what do you think that says as opposed to proposing that the plaintiff will come to 5 million if defense comes to 3.5 million? Note that in these scenarios, the midpoint is exactly the same, 4.25. But I think it sends a very different signal. And take a moment and put a note in the Q&A if you agree with me on that and what you think the difference in the signal is. Um, so, uh, so someone was asking, so unless I did my math wrong here, 5 million and defense comes to 3.5 million, that's 8.5, and half of 8.5 is 4.25. So that's where I got that number as the midpoint. Um, and someone also asked me, would there be an opposing counter bracket? And there will, and I'm gonna show you that. Again, to try to simplify this, and this is what was hard about this presentation, I wanted to kind of stay with the perspective of one party, but we're going to get into Barbara's bracket as well. But I wanted to kind of show you how one party moves. But yes, for each bracketed move, there's going to be a counter bracketed offer, unless the bracket is simply accepted. And that does happen. And we'll talk about that a little more too. Yeah. Okay. I'm just looking at your responses here. Yeah, exactly. So people are saying there'd be a counter bracket. There absolutely would be. But I think this is just to me, how I read these numbers is from 8 million to 500K, that to me is the plaintiff saying, look, I know that you can move a lot more, but I also understand that you've got real limitations in how far you can move, or at least there's the possibility that they understand that. When you're talking about, I'm going to come to 5 million, if you come to 3.5 million, to me, that really suggests it's such a big move for the defense, who, as we know, has very real financial troubles, that to me, it really suggests that the defense is saying, like, this is where we should settle, as opposed to, we're really still moving. And I understand that you're going to have a hard time moving to where I need you to go. So I'm going to keep moving my midpoint down. So I do think the endpoints matter. And there's this kind of feeling about what the endpoint numbers are that can't always be put into words. But I would say that to become really facile with brackets, paying attention to both things is really important. There are other issues that we talked about earlier, like who proposes the bracket. So it's usually the parties, but sometimes it's the mediator, and it can be either one. Most often, I do see the parties do it, or when I'm meeting, I will let the parties do it. But there are times when the mediator proposes the bracket in a very effective way. The nice thing about when the mediator does it is that it's generally more likely to be accepted. So instead of just trading brackets, oftentimes the mediator is going to propose a bracket that he truly thinks or she truly thinks both sides can live with. But to do that, the mediator is going to need to get some information. And in doing so, that necessarily means that the mediator is going to be influenced by the parties. So there's not this kind of pureness about the bracket being, just sort of the next right move. And there can still be some posturing built into it. But if the mediator comes up with a bracket and the mediator has really kind of sussed out the different positions of each side, arguably that bracket will be accepted. One of the ways the mediator can do this is the mediator can say, give me in confidence kind of your best case scenario bracket, and then does this with the other side and can take the midpoints of those brackets and use those as her new brackets. Talk about this in a minute. Again, though, if there can be confusion about who makes the next move. So if Archie proposes 8 million, if Barbara goes to 500K and Barbara accepts that, then pretty clearly Archie moves back. Archie's saying, or Archie makes the next move. So Archie's saying, we'll go to 8 if you go to 500, and Barbara says, okay, I accept that. Now it's on Archie, right, to make the next move and say, okay, we'll go down again if you come up again. But if Carl is proposing the brackets and both parties accept it, then it becomes a little bit more tricky. And this is especially so if, like, Carl, for example, picks a bracket based on brackets that have been exchanged, and he takes, say, the midpoint of the plaintiff's bracket and the midpoint of the defense bracket and makes those a new bracket. So if he's really splitting the baby, and in essence, if he's really taking what he sees as a signal from the plaintiff and a signal from the defense about where they are at right in this moment, where they can live with the case settling, and he splits that and says, all right, that's the bracket we're going to use, then really he's splitting the baby and it's really unclear who moves next. And it would be important for him to just tell the parties, I want the plaintiff to move next. And ideally, or the defense. And ideally, if there's more than one bracket, he's going to switch off so that there is a sense of parity and fairness. I think we have covered this here. Okay, so getting into what happens on the defense side, if going way back to Barbara and GI, do you think they're going to accept Archie's bracket of 8 million if the defense goes to 500,000? If not, why not? And if Barbara counters with a bracket, what would you suggest her bracket be? And maybe just put a couple of thoughts in the chat about why that bracket. So just take a minute. If Barbara and GI will accept the bracket, if you say no, they're not going to accept the bracket, but yeah, I think they would propose one of their own. What would you suggest Barbara propose as a bracket? Anybody? Okay, we got to take her. Mm-hmm. Mm-hmm. Yeah. So, um, so we got some good answers here in the chat. Um, I mean, essentially, I like these answers. Essentially, what I wanted to point out here is I think it's highly unlikely Barbara is going to accept this bracket, only if she was really, really unfamiliar um, with bracketing. But even then, it's just getting 500,000 is getting pretty close to the bottom line the amount of money her client can pony up, or their bottom line. So I'm going to say no, and I think she's going to counter with a bracket of her own. And I think a lot of the numbers that are put in here are good, like 100,000 to 2 million. I mean, essentially what I do when somebody else suggests a number like that is I do look at the midpoint, right? Because I know the other side is going to look at the midpoint. So that is 2.1, and half of that is about $1 million, a little over million, million 50. Did I do the math right? Yeah, 1,050,000. And that, that's from what we know, that might be possible. She might be able to get there. And certainly we know that probably going anything lower than that's going to be tough because the plaintiff understands that there's a lot of value in this case. And essentially they're giving them a big break. Um, so I think that the main thing to do, and again, you could have something like a suggested bracket of 250 to 1 million. And I think that is pretty realistic about where that kind of a number is pretty realistic in terms of where Barbara would counter with her bracket. Because again, just like the plaintiff is going to be expected to, over the course of the day, move his midpoint down, the defense is going to be expected to be slowly moving her midpoint up. So she's going to start with a bracket that they can live with. And so that's why I think this idea of saying, like, 200 or 250, let's say 200, if you go to a million, that's still actually pretty high. That's getting them into 600,000 as a midpoint. But that's the kind of thing that she's going to be looking at. And then, of course, we continue with the dance, and then the plaintiff will come down further and try and push the defense to come up more in the counter bracket. So, couple of other things I want to point out about brackets. So, this whole idea of private brackets or blind or confidential brackets, really, to me, those are all the same idea. Um, and it's not conveying it to the other side, but using a range to allow the mediator to have some room to work with. And also, which I think the reason I like the idea of even if it's a confidential bracket, a bracket is because it necessarily forces both sides to realize there's not one number that is going to get this case settled. There is a range they can live with. One range, is going to be a lot more palatable than another range, or one number is going to be a lot more palatable than another number. But there are various numbers that they can live with, and they may be pretty close together. But again, it's not one number. So having a range can be really helpful in allowing the mediator to do her work and get this thing solved. Um, I think a blind bracket can be really helpful if the mediator wants to initiate her own bracket. So, for example, Carl might say, "Look, Barbara and Archie, say they've gone on and defend, and plaintiff has come way down. Say the mediator has said, like, look, I've really seen these finances. I've done a bunch of research. Like, this is legit. This is a true financial crisis they're in." And so plaintiff has regrettably has decided that they need to come way, way down, but they can live with it. But they still want as much money as possible. Um, and he says that Carl says, look, I need a range from you, a confidential range. I want it to be your last, best, and final. And I want a minimum of $200,000 in that range because I want to get this done. And if we leave this case on the table and say we're $100,000 apart, that's really a stupid thing to do. So give me a little bit of a range. So for example, Archie might submit a range of 1.5 million to 1.3 million. This is like way, way less than he thinks he should take. He's got a PAGA action. He's got a class action that seems to be legit. But he also understands the situation. And Barbara says, all right, we really need to come up with as much range as we can. And so she submits a range of 500 to 700K. Um, and you can see that these numbers may or may not be exactly like that, may not be actually Archie's final truest number that he could live with, but hopefully we're getting in the ballpark. And likewise, hopefully Barbara would be able to go up a little bit too, but she's getting into this range of like a number that is really concerning to her client. And you can graph it out here with the 1.3 to the 1.5, and defense submits 500 to 700. So now we've got a new gap of 600,000, and we're starting to really get somewhere. We're still pretty far apart given kind of the value of the case versus what the plaintiff the value of the case as a plaintiff sees it, and maybe the mediator too, and also what defense is really able to pay. But hopefully we're starting to get into numbers where litigating just doesn't make a lot of sense, especially given the budget that the defense probably has. So there's a whole bunch of ways that the mediator could then use those numbers to settle. He could say, look, if there's an overlap in the brackets, there's a deal. Well, we have no overlap here, right? So that wouldn't work. He can say, if you almost overlap, but there's a delta of, say, 50,000, that's kind of a low number. So, like, maybe a more realistic number might be, 100,000 or 200,000. Then we have a deal, and you basically agree to split the difference of that overlap. So or he might say, if, like in this case, if you're X amount apart, if you're still, $400,000 apart, let's proceed with further blind negotiations and really push the parties to give one last bracket, or maybe two last brackets. If he says, look, we're getting there, I just really need you to move even further. So you can see how these blind brackets can allow the parties still to proceed with big movement with not so much risk because they're not conceding to the other side. Well, at the end of the day, I'm actually could go down to 1.3 million. Only the mediator knows that. They're only going to know that if the plaintiff, or if the defense comes up to a number that they can live with. So a few closing thoughts on brackets. As you can see, brackets can be exchanged privately to the mediator. They can be exchanged publicly to the other side, depending on what path you're using. They can speed up the negotiation, and that's where I think a lot of us mediators really like to use them when we feel like, hey, parties are, let's get this going, let's get this settled, or like if we're not going to get this settled, let's at least figure out what needs to happen, and maybe we adjourn for today and we take this up again in a week or something. We need to figure out what has to happen here, and they can help seal the deal. It is really important that you always know how all the parties are using brackets. That's just essential in order to be sure you're on the same page. It's also important that you double check your numbers. Hopefully these hypos showed you that the midpoints and the endpoints matter. So thinking through how the other side's going to read your number and what the number means to you, what the number is saying in terms of a implied commitment to meet somewhere around the midpoint. And again, being sure that if that's not the case, you let the mediator know that, and have the mediator tell the other side. But totally ignoring the midpoint can create mistrust. So think about that. And then lastly, consider how the bracket's going to look to the other side. As you saw in that example, a bracket with a midpoint of 4.25, there are a lot of different ways you can come up with that midpoint, and the endpoints do matter. So really thinking thoughtfully about where do I want these endpoints to be and what message do I want to signal. Lastly, I want to say, I think brackets sometimes can be a little overused. I think 2 rounds are often optimal. There's no hard and fast rule. And if the parties are actually making really good progress with the brackets, you can certainly get that. You can certainly keep using them and to get the deal done. But I often find they're good at shaking things up, and then going back to single numbers is really the way to do it. And sometimes maybe you have, if it's a particularly difficult negotiation, you might go back into brackets again. But trading brackets all day is not usually the most helpful scenario. Having the mediator give some messaging to the other side about your bracket, how you're using it, what you see. If, for example, you are really wanting to show movement, but also don't want the midpoint to be read a certain way, letting the mediator know that. And always feel free to ask the mediator for input if needed. At Signature, we've got a tool that we can we can put in the midpoint that we want, and then it'll give us a whole bunch of endpoints, or conversely, we can put in endpoints and get a midpoint. So having the mediator kind of collaborate with you on, all right, is that too big of a move? Is it too small of a move? What kind of an endpoint should I come up with here? Um, can be really helpful. And also the mediator can tell you where you can find such a tool so you can play around with the numbers. I think brackets work best when there's clarity in the process. And again, here is all my contact information. Feel free to reach out anytime if you have questions on the presentation. My cell phone number is there, my email, and then if for any reason I'm out of town too, you can always reach out to Jane, my case manager. It was really a pleasure to be here. I will stay, if anyone has questions and wants to ask questions, I'm happy um, to take some questions in the chat. So someone said, isn't the midpoint always the addition of the two new mid endpoints divided by 2? Yes. So as I tried to kind of point out, but it might have gotten lost in the shuffle. The best way to do the midpoint is just to add the endpoints together and divide by 2. Oh, I think I understand what this person is asking. So when we talk about a midpoint, what we're generally talking about is the midpoint of the bracket that's proposed by one party. We're not talking about the midpoint of that bracket and the other party's bracket, unless we're talking about the mediator, and the mediator might be looking at the midpoints of the last brackets. So generally, when we're talking about midpoints, we're talking about the midpoint of the demand or the offer that's being placed on the table. Yeah, someone asked, is there a bracket midpoint calculator? There is, and if you just, I can't off the top of my head tell you where it is, but if you go online and you search for it, there definitely is, and um, the mediator can always give you that information when you're actually in a mediation. I'm not sure I understand, how does this fee shifting play with brackets? Do you mean like um the fee shifting of the actual mediation fees, or maybe you could just say a little more there? Okay. Well, fees by court post settlement. Um, so essentially, the fee shifting, so in your mediation, if you're anticipating that uh essentially you're if you there's a possibility that the court is going to put some fees into place, or say that the court it's a class action and you're concerned that the court might reject some of the terms. Those things should be written into your settlement agreement. Some kind of a decision about what's going to happen if, say, the court decides that the amount that you've come to is not an amount that is acceptable. So that I think gets into a slightly different topic, but I do think that that needs to be put into a mediation agreement. So there's some agreement in place about what happens there. Have you mediated where one party represented themselves instead of having an attorney? Yes. Um, it's tougher, but certainly, absolutely, that is something that, and I think it requires a very different skill set. I actually enjoy that because I tend to connect well. Usually that is a plaintiff, although not necessarily. But I do think it requires a very different skill set. And I do think that's an example of a time when if you wanted to use brackets, you'd have to really sit down with the person and explain to them. Though I will say, I think a lot of lawyers also struggle to understand brackets. So I do think it's a great idea for a mediator to always kind of go over how they're using the term brackets, what they mean, and what they see as important, the endpoints, the midpoint, that kind of a thing. All right, everybody. Well, thank you. It was really a pleasure to be here. And like I said, if you have any further questions, feel free to reach out at any time, and catch you soon.
Alrighty, this concludes today's presentation. Thank you so much, Diana, for an excellent presentation. And thank you so much to our audience for joining us today. Have a great day, everybody.